Hi and welcome to F***ed Up Justice, my new series that examines all the times the US Supreme Court f***ed it up. First up, that time the Supreme Court ruled that black folks were not fully human beings. Buckle up folks, this is gonna be a bumpy and deeply problematic ride. Okay? Before we get into this, let me pay the bills by thanking my partner on today's video, Bright Cellars. I genuinely love this service, you guys. It's so fun and well done. They're a wine subscription service where you take a short online quiz and then they pair you with wines that they think you're gonna like. Every wine I've had from them has been delicious, and I love the convenience of having wine delivered straight to my door. Okay, because I'm not leaving this house. I mean, why would I leave? Okay. My favorite part of these little individual cards that come with each bottle of wine explaining where the wine comes from, what it tastes like, and what it pairs well with. I'm really excited about this Malbec called Ndulu. It's from South Africa and has this beautiful dark color and tastes like berries and vanilla. God, I love wine. Bright Cellars is passionate about helping you discover new wines you'll love while also providing great wine education. They also focus on sustainability by offering sustainable varietals of wine and using packaging that is completely recyclable and plastic free. And Bright Cellars is now offering access to low alcohol wines and sparkling wines, which sound like the perfect light beverage for spring. And what's super exciting is that they are giving my followers a limited time offer of 50% off your first box of 6 bottles. Claim your 50% off by clicking the link in the description below. Thanks, Bright Cellars. All right, let's get into it. The year, it's 1846. The United States is 15 years away from full-blown civil war over a number of divisive issues, chief among them, slavery. The North was like, slavery's bad. Like, we're still mostly racist, but at the very least, people shouldn't be owned, I guess. And the South is like, it's all right as individual states to decide what we want, and what we want is to own people. And everyone is mad. And in 1846, this hasn't reached a boiling point yet, but it was well on its way. At that time, the state of Missouri was very into slavery, and in the West Wing courtroom of the old St. Louis courthouse, an enslaved man was fighting for freedom for himself and his family. That man was named Dred Scott. But let's back it the fuck up a bit. How'd we get here? Dred Scott was a man born into slavery around 1799 in Southampton County, Virginia. He was the legal property of a man named Peter Blow. In 1818, when Dred was about 19 years old, the Blow family moved to a farm near Huntsville, Alabama, with their 5 other enslaved people. By 1830, they had run out of resources as their farming business never took off, so the Blow family moved to St. Louis, Missouri to run a boarding house. This guy Peter had 7 kids, 4 sons and 3 daughters, who all married into prominent Missouri families. They worked in business, politics, and law. This is an important fact for later. Around 1832, Peter Blow died, and Dred Scott was sold to a U.S. Army doctor named John Emerson. As part of his work in the Army, Emerson moved around a lot. In the early 1830s, they moved to Fort Armstrong in the state of Illinois. At that point, Illinois had outlawed slavery. In 1837, they moved to Fort Snelling, which is located in what is now the state of Minnesota. In fact, it's about 20 minutes away from where I'm sitting right now. And the room I'm in was built about 50 years after this took place. History. Cool. Anyway, Fort Snelling at the time was located in the U.S. territory of Wisconsin, which also was a free territory, meaning no slavery allowed. While at Fort Snelling, Dred Scott met and fell in love with 19-year-old Harriet Robinson. She was also enslaved by a guy named 𝗦𝗨𝗣𝗥𝗡𝗏𝗧𝗏, who was an Army officer and Justice of the Peace in Fort Snelling. He officiated the marriage of Dred Scott and Harriet Scott and gave Harriet to Dred Scott's enslaver, Emerson, so that the couple could be together. Aww. Okay, but don't go feeling nice things about old Lawrence. All right, he owned 20 other humans, so like not a good person, but like to do little nice deeds once in a while to feel good about himself, you know? Cute. Anyway, so Dred and Harriet are married in a free territory after Dred had spent years with Emerson traveling around free states and territories. Interestingly, because of various treaties, Dred could have sued for his own freedom while he was actually in those other territories. A lot of historians like to note the mystery of why he never did sue while he was in the actual free territory, but like, disenfranchisement runs deep. You know, he couldn't read or write, and the legal system was even more exclusionary then than it is today. Sure, yeah, I've been held in bondage my entire life and told I'm subhuman. Let me climb up these court steps and sue my white enslaver. You know, this was a process that many enslaved people went through, but the barriers to entry were huge. So I find it kind of victim-blamey, all the historical accounts I read where people are like, huh, what a mystery that it took him so long to sue. Anyway. In 1837, Emerson was transferred from Fort Snelling to Louisiana, but he left the Scott family behind in Fort Snelling to lease them out to other officers. While in Louisiana, old Emerson, he meets and marries 𝗬𝗓𝗦𝗓 Sanford. Eventually, they were reunited with the Scots up in Fort Snelling, and then they all moved back to Missouri in 1840. You'll remember, Missouri is a slave state. Anyway, Emerson suddenly dies in 1843 at the age of 40. The official cause of death is consumption, but rumor has it was syphilis. Emerson's widow Irene gets his estate, so she leases out the Scots' labor for the next 3 years. At this point, Dred and Harriet have 2 girls, Eliza and Lizzie. In 1846, Dred tries to purchase freedom for himself and his family from Irene, but she was like, nah. That ain't happening. And so that same year, Dred starts the legal proceedings that would eventually lead to the Supreme Court decision that we're talking about today. The first case Scott filed was in Missouri State Court, and he relied on the long-standing Missouri judicial standard known as once free, always free. The standard allowed slaves who were taken to places where slavery was outlawed to then be freed, even if they returned to the slave state of Missouri. His wife Harriet filed a separate lawsuit for her own freedom as well, and the 2 lawsuits were later combined into one that represented the whole Scott family. They were assisted in the initiation of their suit by a guy named Francis Murdoch, a white attorney who filed nearly 1/3 of all freedom lawsuits in St. Louis between 1840 and 1847. He initiated the lawsuit and paid the fees necessary for its initiation. He relied on the once free, always free judicial standard, which again was long-standing and well-established by numerous court cases, all the way up to the Missouri Supreme Court that allowed enslaved people to sue for their freedom and win. He likely would have told the Scots that they had a strong case. It met all the requirements. The problem is that the judicial standard no longer reflected judicial and social attitudes about slavery by the mid-1840s in Missouri. Remember, we're 15 years away from the Civil War, but things are already boiling over. Between 1844 and 1846, 25 freedom lawsuits were filed in state court in St. Louis. Only 1 had resulted in freedom. Murdoch moved to California before the Scots case went to trial, and at this point, for reasons that are still unknown, the Blow family, that original family that owned Dred, remember? The guy Peter, he had 7 kids. Yeah, and his kids started getting involved and supporting the Scots suit. It's thought that Charlotte, one of his daughters, was the matriarch in the family and persuaded her brother-in-law, a prominent lawyer named Charles Drake, to assist the Scots on their case. And then when Drake moved away, Charlotte got the attorney for the Bank of Missouri to represent the Scots. Charlotte's husband, you see, worked at the bank, which is the only apparent connection that would make sense for this random bank lawyer to have gotten involved in this case. I point this out to again highlight the many hurdles that enslaved people had to overcome to get a freedom case brought to court. That the Scots were able to initiate their cases was due in part to their tenacity and bravery, but also in part to a community of people who helped. A lot of stars had to align for this case to have even started. Anyway, the case went to trial in 1847 before a Missouri judge whose name was Alexander Hamilton, but not the Alexander Hamilton. And I checked his family tree, and as far as I can tell, this judge, Alexander Hamilton in St. Louis, he has no actual relation to the Alexander Hamilton. Anyway, the way these freedom claims worked is the enslaved person had to claim that they were being falsely imprisoned by their enslaver. And to do that, they had to show that the enslaver treated them as slaves. So in the initial trial, they did this by bringing forth a guy named Sam Russell, who testified that he had hired Dred and Harriet from Irene and paid her father, Alexander Sanford, because women couldn't, make contracts or touch money, However, then Irene's defense was like, no, not so. And on cross-exam, it was revealed that Sam Russell's wife, Adeline, was actually the one who made the arrangements to hire Dred and Harriet from Irene. Sam had just paid her dad. And that one piece of testimony Sam had given, that he hired Dred and Harriet, was dismissed as hearsay, because the testimony was really, my wife hired them, which would require his wife to then come and testify that she was the one who did it in order for it to be admissible. I'm not sure why they didn't consider that, or know that, or include Adeline as a witness. Probably because women's brains can't really handle, giving witness testimony, Anyway, so on this technicality, the Scots lawyers didn't properly prove that Irene, the enslaver they were suing, held the Scots out as her own enslaved people. So the jury found for Irene. This is something that happens all the time in our legal system. The root of the issue is never even touched upon. It's just technicalities that decide a lot of lawsuits. But at the same time, technicalities like hearsay are important rules of evidence that are put in place to keep the system fair and the standards for evidence high. So it's a tricky subject. Anyway, the Scots managed to get a retrial, but then there were years of delays before the retrial was able to happen. The issue was brought all the way up to the Missouri Supreme Court, but by that point, the trial court had already granted the new trial. So the Supreme Court was like, this is moot. The retrial was already granted. Then before the retrial could happen, it was delayed several times due to the court being backed up. Then a huge fire broke out in St. Louis, so it got delayed again. Then a major cholera outbreak delayed the proceedings even further. here. So remember, this lawsuit was initiated in 1846. The retrial wasn't heard until 1850. And all they had to do in this retrial was present the facts again, but this time have Adeline testify that she was the one who hired them from Irene to prove that they were actually being held as slaves. That's it. An hour or two of testimony, but it took 4 years to get it right. And this time the jury found for the Scots because they proved that they were being held as slaves even though they'd traveled to free states and territories, and firmly held Missouri precedent said that that made them free. Obviously, Irene appealed this decision, and it was appealed up to the Missouri Supreme Court in 1851. At this point, Irene's appeal had the major issues laid out that would eventually make their way to the Supreme Court. They argued a number of things, but most importantly, they argued that the United States Congress's prohibitions against slavery in the free territories were unconstitutional. So this made the case bigger than just, were the Scots in free territory and still being held as slaves and should therefore be free? Instead, it became, can the United States Congress grant freedom to enslaved people, or is that beyond the scope of what the Constitution allows Congress to do? Because you see, enslaved people were seen as simple property, just like any other piece of property. So the argument, in oversimplified and horrific terms, was that the Constitution didn't give Congress the right to take away people's property, and it certainly didn't allow other state laws to take away people's property. Like if you drove your horse and buggy from Missouri to Illinois, but in Illinois owning a horse and buggy was outlawed, Illinois couldn't seize your horse and buggy once you went back to Missouri. That's how they saw it. And the Missouri Supreme Court reversed the lower court decision and found for Irene and against the Scots. The constitutionality wasn't decided at this juncture, but instead the justices decided that all the precedent that had come before that allowed enslaved people to become free, well, it hadn't considered Missouri's laws in that. It was just based on laws in other states and territories. So instead, they said now your slavery status reattached upon re-entering Missouri, with the opinion stating that slavery was the will of God and that times now are not as they were when the former decisions on this subject were made, which basically admitted that racial and sectional prejudices influenced this decision. Okay, so that was the end of the line for the Scots in state court. Once you reach the highest court in the state, there's nowhere else to appeal to. But that doesn't mean it's the end of possible judicial remedies. So the way the court system is set up in the United States is that it is two separate systems. A state system where there are many trial courts in a state, a court of appeals, and then a Supreme Court, though the way the courts are named differ in some states. For example, the lowest court in New York State is called the Supreme Court, and the highest court is called the Court of Appeals. So you appeal a case up from the Supreme Court to the appellate court, because I guess New York always has to be special in some way. Anyway, that state system is separate from the federal system. The federal system has district courts, then courts of appeals, and then it all appeals up to the Supreme Court of the United States. Because these are separate court systems, you can restart a case on the same issue in federal court after you've exhausted your state court options. But this is only available if you are suing based on federal law. Like, you can't go to the federal court system and be like, he trespassed on my lawn, because that's a state issue. That's a state law question between two people who live in the same state. The feds don't need to get involved. But if you're suing based on federal law, or you're suing someone from a different state about an issue that's worth over $75,000, then it can go before federal courts, because then it's between states and there's a lot of money involved, so it's worth it for the feds to get involved. Anyway, so the reason why the Scots were able to bring this case in federal court was because at some point, historians have no clue how or when or why, the ownership of the Scots was transferred from Irene to her brother John Sanford, which is why the case eventually became Dred Scott v. Sanford. And John Sanford, he lived in New York. Different states. Feds can get involved now. You follow me? Great. So in district court, the Scots again claimed that they had gained freedom when living on free soil, and Sanford countered, most importantly, with the question, can a person who was of African descent, meaning they or their ancestors were brought to the United States to be enslaved, can someone like that sue in federal court at all? Because are they even citizens? At that point, the district court said the Scots could sue, that the fact of their ancestry didn't bar them from suing. However, the district court was like, you can sue, but your lawsuit, yeah, it sucks. You lose. Okay, so you know how I just explained about how in the federal court system you have district courts, then courts of appeal, then the Supreme Court? Well, those courts of appeal, they weren't created until 1891 as a means of lightening the Supreme Court's growing caseload. So at this point, it's 1854, you just have district courts and then right to the Supreme Court. So the Scots' final judicial remedy was to appeal that federal district court's decision that their lawsuit sucked up to the Supreme Court of the United States. At the Supreme Court, the Scots again argued that they had the right to sue and that Missouri's once free, always free precedent should be upheld. Sanford argued again that the Scots didn't have standing to sue, meaning they shouldn't be allowed to sue because enslaved people aren't citizens. And even if they did, the abolition of slavery made by Congress in the 1820 Missouri Compromise, which affected the territories that the Scots claimed made them free, yeah, that wasn't a valid thing for Congress to have done. Enslaved people are property, and Congress can't take away people's property like that. The final decision of the Supreme Court came down in 1857. 1857. Remember how this whole case started in 1846? Yeah, this has been going on for 11 years. And now it's 1857 and we're 4 years away from all-out civil fucking war over this very issue. So the court had a lot to say. 200 pages of things to say. I usually try to read everything for you guys before making these videos, but no. And this case was unique in that it was a 7-2 decision, but each of the 9 justices wrote their own opinions. Despite this, Chief Justice Taney's opinion is considered the majority opinion that is cited to today. And it's a damn doozy. Again, I didn't read the whole thing because holy shit, but it is clear from the decision that Taney was a staunch textualist, meaning he believed that the Constitution has to be interpreted based on the original understanding of the words at the time the Constitution was adopted. This is problematic for a whole host of reasons, not least of which being the Constitution is meant to be a living document that changes with the times. It was written in 1787, so it's old as dirt, and in the US we hold out the Constitution to be this sacred cow that's due complete and total reverence, but then the majority of the US has never actually read the Constitution, nor have we read the literal hundreds of years of judicial precedent interpreting that Constitution. In the US, we have the shortest written Constitution of any major government in the world. The shortest. The framers knew they couldn't answer every question that could ever come up, so they left things intentionally vague to allow for interpretation. Let me stop myself before this turns into more of a rant than it already is. As I was saying, Taney's opinion looked at the words citizen and we the people in the Constitution to determine whether those words applied to enslaved people of African descent at the time the Constitution was written. And he determined that there was no way this could be the case because most of the framers were enslavers in a society that didn't question slavery, which is ignoring the truth that there very much were abolitionists and disagreement over enslaving humans at the time the Constitution was written, and they clearly knew something was wrong with it considering they gave a hard deadline for the importation of people from Africa as part of the written Constitution. And Vermont had abolished slavery in 1777. There were plenty of facts he could have relied on to support the idea that formerly enslaved people should, at the very least, have the right to sue in court. This could have been a very narrow ruling about just that, but instead Taney made it a broad, sweeping ruling, likely due to outside pressures on the Supreme Court to make a determination once and for all about slavery. And boy did he. The most infamous line from this opinion, and this is going to be really offensive, describes that at the time the Constitution was written, people of African descent were, and I quote, regarded as beings of an inferior order and altogether unfit to associate with the white race either in social or political relations, and so far inferior that they had no rights which the white man was bound to respect, and that the Negro might justly and lawfully be reduced to slavery for his benefit. Taney goes on to say that enslaved people were bought and sold and treated as an ordinary article of merchandise in traffic whenever a profit could be made by it, and this opinion was at the time fixed and universal in the civilized portion of the white race. It was regarded as an axiom in morals as well as in politics, which no one thought of disputing or supposed to be open to dispute, and men in every grade and position in society daily and habitually acted upon it in their private pursuits as well as in matters of public concern without doubting for a moment the correctness of this opinion. And Taney could have stopped there and said, nope, not citizens, this case can't go forward. He didn't have to address the constitutional questions of whether enslaved people were property that governments can't take away, or whether Congress had the right to create free states out of the Missouri Compromise. He didn't have to get into that. He didn't have to get to the constitutional questions that were tearing the United States apart at the seams. But he was like, nah. Hold my beer. Taney was like, listen, enslaved people are property, and the Fifth Amendment protects against unlawful seizures of property. So any law that deprives an enslaver of his property was therefore unconstitutional. And he said these free states created by Congress through the Missouri Compromise, yeah, also not constitutional, because it goes beyond the powers given to Congress by the Constitution. And in making that decision, Taney soundly closed the door on the federal government's ability to step in on the subject of slavery, leaving it to individual states to determine, which basically set the states at odds with each other, increasing tensions between the North and South, and adding fuel to the fire of the brewing civil unrest, which erupted into civil war 4 years later. Fate continued to play a role in Dred Scott's life, however, because remember Irene, the widow of Emerson, the army doctor, the one that the Scots originally sued to get their freedom? Yeah, well, she remarried a guy named Calvin Chaffee, a congressman from Massachusetts who was a staunch abolitionist. And apparently he just didn't know that she claimed ownership over the Scots. Anyway, he found out a couple months before the Supreme Court decision came down, probably because newspapers nationwide were like, hey, you know this insane Supreme Court case, Scott v. Sanford, that we're all waiting to see to determine the outcome of slavery in America? Yeah, well, Chaffee, that abolitionist congressman, his wife is the one who claims to own them. So Chaffee is pissed and embarrassed and transfers ownership of the Scots to Taylor Blow back in Missouri. Again, remember the Blow family? They were the original enslavers of Dred Scott, who had since spent a lot of time and money and used their connections to help his case for his freedom. Now that they were the rightful owners of the Scots, they could begin the process of emancipating them. And on May 26, 1857, Dred and Harriet Scott were formally freed in St. Louis Circuit Court by that same judge, Alexander Hamilton. After obtaining his freedom, Dred Scott worked at a hotel in St. Louis, and Harriet worked as a laundress. Unfortunately, Dred Scott died of tuberculosis on September 17, 1858, just 18 months after obtaining his freedom. Harriet would live until 1876. Back in 2017, the podcast More Perfect, which if you haven't heard of it, is an excellent podcast all about constitutional law and the Supreme Court, I highly recommend. They did an episode called American Pendulum 2 about the Dred Scott case, and they covered a reconciliation summit that was held between the descendants of Dred and Harriet Scott and the descendants of Justice Taney, who wrote this opinion. It's a really interesting look at history and how we talk about it now and reconcile with it now, with a lot of mixed emotions and interesting discussions. I highly recommend. Thank you once again to my partner on today's video, Bright Cellars. Reminder that they are giving my followers a limited time offer of 50% off your first 6-bottle box. Claim your 50% off by clicking the link in the description down below. Thanks, Bright Cellars. If you're interested in learning more about some fucked up shit that the US Supreme Court has done, I suggest checking out this video that I made a little while back all about the 𝗬𝗦𝗣𝗏 decision, which validated the use of Japanese internment camps on US soil during World War II. Thanks so much for watching. Have a good day. Goodbye.